5 seconds. Start. In the case of UP State Road Transport Corporation and others, appellant versus Brijesh Kumar and another respondent on August 28, 2024 under challenge in this appeal by the Uttar Pradesh State Road Transport Corporation is the order dated 12/9/2018 passed by the Division Bench of the Allahabad High Court in letters patent appeal arising from a writ petition filed by the respondent, wherein the learned single judge wide judgment and order dated 12/1/2018 allowed the writ petition of the respondent after setting aside the order dated 30/1/2016 terminating the services of the respondent passed by the Assistant Regional Manager Mathura, UPSRTC. The father of the respondent Balkrishna was a regular conductor working with the appellant UPSRTC who died on 18/10/2003 while in service. At that time, the respondent was a minor. His mother moved an application for his compassionate appointment but in vain. The respondent attained the age of majority, that is 18 years, on 10/7/2008. He acquired the educational qualification of high school and intermediate. His mother thereof again moved an application seeking compassionate appointment for him under the Uttar Pradesh Recruitment of Dependents of Government Servants dying in Harness Rules 1974. There was no response to the above application filed by the mother of the respondent. However, subsequently wide letter dated 19/10/2012, the appellant UPSRTC informed the respondent that in connection with his application for compassionate appointment, the corporation has decided to appoint him on preferential basis as a contract conductor. Accordingly, he was requested to report to the office and to deposit a security amount of rupees 10,000. It appears that in pursuance thereof, the respondent submitted the security deposit and entered into an agreement with the appellant UPSRTC on 12/12/2012 to function as a contract conductor. The respondent thus joined as contract conductor. During his service as contract conductor, he was found guilty of carrying 3 passengers without ticket on 2 occasions and on 1 occasion was found carrying 500 kg of extra luggage without booking. His services were thus terminated on 30/1/2016 on the ground of misconduct. The respondent challenged the order dated 30/1/2016 terminating his services, challenging that he was appointed on compassionate basis and therefore was a permanent employee whose services could not have been determined without holding a disciplinary inquiry. The writ petition challenging the termination order was allowed by the learned single judge White judgment and order dated 12/1/2018, and the same was upheld by the division bench by the order impugned herein dated 12/9/2018. The High Court concurrently held that the appointment of the respondent was on compassionate basis, and as such he was a permanent employee whose services could not have been terminated on account of any misconduct without holding a disciplinary inquiry. In the above background, the appellant UPSRTC has come up in the present appeal. The submission of Srimati Garima Prasad, Learned Senior Counsel for the appellant UPSRTC, is that the respondent was never appointed on compassionate basis under the dying in harness rules. His appointment was contractual basis independent of the dying in harness rules. Since his appointment was on contractual basis, his service have rightly been determined on the alleged misconduct. Shri Sudhir Kumar Saxena, Learned Senior Counsel for the respondent, on the other hand, defended the order of the High Court, contending that the compassionate appointments are always of permanent nature and the services of such employee cannot be terminated without holding a disciplinary inquiry. Therefore, the High Court has not committed any error of law in setting aside the termination order and holding that the services of the respondent are of permanent nature. There is no dispute to the legal proposition that any appointment made on compassionate basis is in the nature of a permanent appointment and is not liable to be treated as temporary or contractual. However, the fact remains whether, in the instant case, the appointment of the respondent is under the dying in harness rules or is independent of it on contractual basis. Undisputedly, the father of the respondent died on 18/10/2003 while working as a regular conductor with the appellant UPSRTC. The mother of the respondent had applied for his compassionate appointment, but no such appointment was offered to him as he was a minor at that time. Even upon his attaining the age of majority on 10/7/2008, the respondent was never offered any compassionate appointment. The record reveals that instead of offering compassionate appointment to the respondent under the dying in harness rules, the respondent was extended the benefit of the policy decision dated 9/8/2012 taken in the 188th meeting of the Board of Directors of the appellant UPSRTC. Accordingly, appellant UPSRTC White, later dated 19/10/2012, offered contractual appointment to respondent as conductor pursuant to his application for compassionate appointment. The respondent duly accepted the said offer and, in response thereof, submitted the security deposit and entered into a written agreement on 12/12/2012 accepting the contractual appointment as conductor full stop.